Hi, thank you very much for coming. I'm Peter Rosenblum, and I am the faculty co-director of the Human Rights Institute at Columbia Law School, and it's a pleasure to welcome you all here today. I'll just say two words and then turn it over to Michael Ratner, who represents the co-sponsors of today's event. It really is a great pleasure for us to see this event come together in the way that it has. It was in part and largely at the initiative of the Center for Constitutional Rights that we came together to start this event. And I would say one of the issues, one of the reasons why in particular working with CCR on this is so important is that the issue of accountability in relation to violations of international law in time of conflict is obviously one of intense importance. And it's one on which the Center for Constitutional Rights has always been devoted and has helped to further the jurisprudence in this area in places around the world. And I think that bears noting and mentioning because, in general, accountability has often sat somewhat uncomfortably, awkwardly, or ambivalently with international law, with human rights, and with humanitarian law. And to a younger generation, I think that might seem a little bit strange because it certainly came into a kind of vogue with the end of the Cold War, as if it had always been there. And there were many who thought that we were on, at that point, a march forward that would lead towards continuous progress, whether around universal jurisdiction, transnational litigation of other kinds, or because of the international courts that were in place. But in fact, the counter forces, the alternative trends, the active opposition to accountability is a reminder of how problematic, in a sense, it has always been, and how, while on the one hand there may be progress in terms of jurisprudence, there are also barriers that don't necessarily lead in any single direction, certainly not towards the light or towards progress in all cases. We've also seen in the last couple of years an increased active resistance. What you won't find a lot of discussion of here today is something called lawfare. And there's a reason for that, because while those who have been promoting lawfare feel that they should also be in the room, there are some of us who think that, in fact, it's diametrically opposed to the very movement that we've been a part of and the process that we're going through. So it may be the ultimate goal, even of those in the room, to learn about the process in order to stop it. But here today, we're really going to learn that process. We're going to look at the opportunities, the jurisprudence, and some of the specific developments in parts of the world that have enabled more accountability. I'd like to thank the two people who really did organize this. That's Aliyah Hussein of the Center for Constitutional Rights and Greta Moseson. These two have really been phenomenal in enabling us to organize this and keep the rest of us on a schedule. So at this moment, let me turn things over to Michael Ratner, our friend and Columbia alum.
Good morning. I was walking over, I was telling Wolfgang Kolek, who's here from the European Center for Constitutional and Human Rights, how even though I went to this law school 40 years ago, it's the one thing that still gives me butterflies walking up the street. Because and Wolfgang said, you always remember that exam, the nervousness that they would just call on you in class and poke a finger at you and say, Mr. Ratner, what's the answer to that? Anyway, that was 40 years ago. Today, I'm really glad to be here, and glad to be here with Peter Rosenblum and the Columbia Human Rights Institute, which is the co-sponsors of this remarkable program. The center is the co-sponsor. We have two of our lawyers here who are key in this area of our work. That's Katie Gallagher and Maria LaHood. You'll hear from them this afternoon. When I look through the schedule, it's actually a remarkable day of presentations. I mean, there's really the key litigators on accountability for international human rights violations are going to be in the room over the rest of this day. And they've come from all over the world. And I would point out each one, but there's one I do want to introduce because he has come from all over the world, but he's also had to get through a special block, and that's Raji Sourani, who's sitting over there, the head of the Palestine Center for Human Rights. And this is Raji's first trip into the United States in 11 years, and that's because this is the first time that our State Department has been willing to grant him a visa to come into the United States. So it's a special real occasion to hear from a lot of us, and to hear from Raji in particular. Now, many of us in my career, and certainly the Center has illustrated that, have the belief that the powerful, those who were at least once very powerful, should be held to the same standard of human rights as the losers, as the poor, as the weak. And one of our goals, certainly at the Center, has been trying to equalize that, to see that international accountability doesn't just apply to the weak, to the losers, and should apply to the victors as well. So, for example, we have special courts for crimes in Sierra Leone and Cambodia. We have UN courts for the former Yugoslavia and Rwanda. We have an ICC that prosecutes primarily abusers from Africa. And this is not to underestimate those human rights crimes, but is to say that our human rights jurisprudence focuses really on a particular set of people who are not the most powerful people in the world. But as you'll see, there's no such courts, no such ICC prosecutions for torture or war crimes by the United States, by officials from other powerful or protected countries, Israel, Sri Lanka, other countries as well. And the idea that some of these countries have this vibrant domestic system that can take on those issues is really just a fiction. They don't, and they don't take on those issues. And it's a serious issue not only because I think there has to be some equality in this, but the failure is more than just hypocritical. What it does is it robs these standards that are supposed to be universal. It robs them of their universality when you only apply them to certain parts of our world. It makes the prosecutions of the weak and defeated appear as victor's justice. It makes fundamental human rights protections appear to be a political tool that's wielded by the powerful to bash the less powerful. And of course, without accountability, the powerful will again and again violate human rights with impunity. And of course, I don't want to leave out, when you don't prosecute major human rights violators who are powerful, you leave the victims and survivors without any sense of justice. The perennial question for me and for the Center has since the beginning been, how do we hold the powerful accountable? How do we equalize justice even a little bit? How do we make fundamental rights really universal? And we have tried over the years to try every system we can. My first case at the Center, I walk into the Center September 7th, September 9th, 1971, the Attica Rebellion happens. By September 15th, I'm up at Attica interviewing prisoners who've been tortured. My first case brought at the Center was to try and prosecute New York State authorities for the slaughter that took place at Attica, for the killing of 39 inmates and guards together. Of course, we lost because there's no way in the world in the United States individuals or survivors or victims can bring criminal cases. But in the end, we wound up getting all of the charges dismissed against the guards. So it was against the inmates as well as all of the charges, as well as no charges against the guards. So it was a success in a way, but not the success I completely wanted. CCR also developed, and you'll hear about it, a civil remedy for international abusers of human rights. And one of the people who developed that you'll hear from, Peter Weiss. He'll be here at lunch. He's here now, I think. And that's the Alien Tort Statute. Came out of the Center for Constitutional Rights. We were extremely successful at saying torture is a violation of international human rights. A torturer is like a pirate and can be brought to justice wherever in the world they are found. That precedent, it's a civil precedent, it's a damage precedent, That precedent we have used successfully, as have now many others, used extremely successfully for torturers who come into the United States, for people who disappear people who come into the United States. We've used it very successfully. At the same time, where we have failed to be able to be successful is, of course, against the United States for its own torture. So, for example, we brought a case against U.S. killings and torture and support for them in Nicaragua in the 1980s. We got thrown out of court. We brought 2 cases against a high level of Israeli officials, both cases thrown out of court. So we failed to be able to use that precedent for civil liability in the U.S. Likewise, our recent efforts to hold U.S. people accountable for the current torture regime that took place under Bush have been essentially a failure. We've lost almost every one of the cases, despite how good those cases were. And, of course, the efforts of the Center, as well as many organizations, to get criminal prosecutions of the torture team within the United States have not worked. So we've used many different ways in which we try and get accountability. One mechanism that you're going to hear about today is the use of national courts and universal jurisdiction to do it. And what I like about them, there's all kinds of gates and difficulties, and they're hard cases, and they take years, is I always like the fact when individuals and survivors and victims can go into a court and begin a case, whether it's a civil case here or a criminal prosecution in the courts of Europe or Latin America, because it's like acting like a private attorney general, and it takes it outside of prosecutors who are political, a political system that doesn't want these prosecutions, and it has a great advantage. It's difficult, it's hard, and you'll hear how difficult it is. But it at least gives me some hope that national courts that have universal jurisdiction can somehow get closer to some semblance of justice against the powerful. And that's why, as you'll hear today, why the Center and the European Center for Constitutional Rights have gone to Germany, to France, to Switzerland, and to Spain to go after those people in the Bush administration who have engaged in and openly and publicly admitted torture. Now, just a word about the national courts, and Reed Brody will be here, I guess, this afternoon. But when Reed worked on the Pinochet case in 1998, and from that case, we figured this was really going to be the big major opening where national courts exercising universal jurisdiction could actually take on cases all over the world. Of course, the promise of the Pinochet case has been much harder to realize than I think Reed or I expected 13 years ago. Reed will tell you about that, but at the same time, it has caused it has allowed us to do some kinds of work on accountability. And we're continuing to do so. It's opened a door. Countries have put up more and more gates, but we're getting through a number of those, and Reed will tell you about his experiences. And I can go on about this, but the one thing I would say at this point, looking at what we've done around the torture issue in the U.S., we haven't gotten Bush in jail, we haven't gotten Cheney in jail, we haven't gotten Rumsfeld in jail. But I can tell you this. They're not going to be visiting the Prado very soon. They're not going to Switzerland. They're staying out of Europe. So we're making some progress. And I think today is really a day to look at the progress we've made, where we haven't been able to make progress, and in my view, somehow how we can equalize the incredible situation in which the powerful are able to put the powerless into prisons, into trials, but they themselves feel they have impunity from fundamental violations of human rights. So it's going to be a great day. I'm really looking forward to it myself. So thank you very much.